All rise. The Honorables, the presiding Chief Judge and judges of the Court of Appeals of the State of North Carolina. Oh yes, oh yes, oh yes. The Court of Appeals is now in session. God save the state and this honorable court. Be seated.
All right. Well, good morning. We ready to start on our, okay. Good morning. I have to check on our live streaming and make sure our technical stuff is okay. Welcome to the Court of Appeals. And let's see, we have two cases for argument this morning. Your panel for the cases today includes me, Judge Donna Stroud, and then to my right, Judge John Tyson.
Morning.
To my left, Judge Lucy Inman. And our first case for argument is State v. Lane, and it looks like you're all in place and ready to proceed on that. So, move this mess out of the way. And, all right, and you can come on up. We have the timer automatically set for 5 minutes of rebuttal time, so if you want something different, just let us know and we can reset that.
May it please the court, counsel, I'm Assistant Appellate Defender Michelle Goldman, and I represent Mr. Lane in this appeal. This appeal raises a question of whether Mr. Lane has standing to challenge law enforcement's continuous search of the car he drove. Under the binding precedent of Katz, Jones, Byrd, Carpenter, and our own Supreme Court's decision in Reed, the answer is definitively yes. Mr. Lane has standing under both the reasonable expectation of privacy and trespass theories announced by the U.S. Supreme Court. This case turns on whether society recognizes as reasonable an expectation that the government will not secretly install GPS devices on private cars and remotely collect detailed information concerning the car's location, speed, and movements. Alternatively, the case raises the issue of whether Mr. Lane had a sufficient property interest in the car he lawfully drove to object to the government's trespassory search.
Are you challenging Judge Collins' issuance of the GPS order?
That issue is not before this court because no trial court ever allowed Mr. Lane's challenge to the warrant to be heard.
I understand, but are you contesting the validity of that underlying order by Judge Collins?
Certainly, Mr. Lane contests the validity of that order, but that issue is not ripe for this court's review. It hasn't been briefed. It hasn't been argued, and no trial court has ruled on it. And under State v. McKinney, our Supreme Court has said that the validity of a warrant, which the state argues this order essentially was, must be determined in the first instance by the trial court and not by an appellate court.
So we do presume an order of the court is valid, correct, until shown otherwise?
I don't even think that presumption comes into play in this case because there's no issue before this court about the validity of that order.
Well, if the order is valid, then it goes to whether or not it would cover your client. So if we presume it's valid, then the issue would then become, does your client have the right to challenge an otherwise valid order, correct?
I think the issue is, does my client have standing to challenge a search of the car that was conducted by the government putting a GPS device on it? And I think that issue it's clear that he does. Whether or not that order authorized the search is an issue for another day.
Okay, let's talk about the basis on which there's no dispute your client was driving. Is that correct?
That's correct.
Is there any dispute that he was speeding?
The trial court found, and we have not challenged on appeal, that there was reasonable suspicion that he was speeding, and the stop just based on the speeding was valid, and we have not challenged that on.
Okay, would that not be an independent basis for reasonable suspicion and probable cause to search, regardless of whether or not he would have standing to challenge the underlying GPS order?
Respectfully, I don't believe so, Your Honor, because if the underlying order for the search is invalid, that observation of his speeding was tainted by the unlawful order. It was undisputed that the officers would not have been where they were to observe the speeding, would not have known anything about the location of this car or had any interest in stopping it, but for the GPS monitoring that occurred in the 20-hour period that Mr. Lane was in the car.
So your assertion is the pulling over for the admitted speeding where your client was admittedly driving must be totally random. Is that correct?
No, I don't think that's the analysis. I think the analysis is, and this is an issue that will be adjudicated if this court remands for a hearing, allowing Mr. Lane his day in court to challenge the order. The issue will be, did the speeding or the observation of speeding attenuate any taint from that original order? That whole attenuation argument was never explored because Mr. Lane never had a chance to challenge the constitutionality of the search.
You agree even an illegal search can be broken by independent or intervening circumstances?
I certainly agree with that, Your Honor. I don't believe, and again, this has not been briefed for this court, it hasn't been argued, but I don't believe that the observation of speeding could meet the test for attenuation in this case. The Officer Mitchell, I believe, candidly testified, and the other officers who participated in the stop, that they would not have been there but for the GPS, the information provided by the GPS tracking. This was a highly coordinated effort entirely based on the GPS tracking. The attenuation doctrine looks at whether there's been a delay or a break in the chain of events from the onset of the illegal government action, and I think the state in this case would be hard-pressed to make that showing.
I think that someone who was named in the order, Judge Collins' order, was actually a passenger in the car. Is that correct?
That's correct.
And that person had the permission of the owner to have possession of the car?
That's correct, as did Mr. Lane.
Okay, and your client had permission through that person, though, correct?
I don't know that that issue was exactly clear. I know that the state stipulated in its briefing on the issue of standing that Mr. Lane had permission of the registered owner to possess the car.
Irrespective of the order, if during a valid traffic stop, if an officer smells contraband, does that give him suspicion to proceed further on a search?
That's an interesting issue. I think that's currently before the court in some other cases in terms of whether or not the smell of marijuana actually gives an officer probable cause to search now that our state has legalized hemp, which smells identical to marijuana. But I don't quibble with the court's, what the court I think is asking is that if the officer develops probable cause for a search during a stop, does that with the automobile exception, allow the officer to search the car without a warrant. And I think clearly that's true. But again, this case isn't about just the stop and what happened in the stop separate from the order.
We go to your ability to show prejudice, because even if we agreed with you that your client had the right to contest the GPS order, if there's an independent basis to sustain the conviction, then you cannot show prejudice.
I think the prejudice is that if he had prevailed at the motion to suppress hearing, the evidence against him would have been suppressed. He never had the hearing. That is fundamental prejudice, to be denied your day in court that you are absolutely entitled to under the facts of this case. I don't see how where this court is not in a position to decide the underlying issue in the first instance, it can sort of decide it against Mr. Lane and then say he can't show prejudice because he was denied the chance to even challenge the order.
Ms. Goldman, is it your argument that the issue of prejudice, the issue of whether or not there was an independent reason to stop and perhaps search this vehicle are issues that we can't get to until we resolve the issue of standing.
Yes, Your Honor.
And if this case were, if this panel were to agree with your argument that Mr. Lane has standing, this panel isn't necessarily going to reverse on the merits, the trial court denial of a motion to suppress, but simply remand to the trial court for a hearing on the merits?
That is correct, Your Honor. I mean, what Mr. Lane is asking for here is actually a very limited ask. He's saying, I request my day in court to challenge the validity of the order. It in no way decides the issue of the validity of that order or any issues regarding the attenuated nature of the traffic stop itself or the subsequent search.
Thank you.
One thing I wanted to just briefly touch on before I launch into the analysis under reasonable expectation of privacy and trespass is the standard of review that this court must use and what this court must consider. It is a de novo review because Judge Young summarily denied Mr. Lane's motion to suppress based on standing. And under this court's precedent, the court looks at the evidence that was submitted to Judge Young to make that determination, conducting its own de novo review. And I wanted to just kind of briefly touch on some of the evidence that was before Judge Young when he made his decision. Mr. Lane drove a car that belonged to Sherry Harris. Mr. Evans lived with Harris and used the car. Mr. Lane drove the car with permission. Mr. Lane had made the trip from Raleigh to New York numerous times before. Mr. Lane drove for most of the 20-hour trip because he knew the route. Sometimes Mr. Evans slept while Mr. Lane was driving. Evans had never taken the trip before. Evans was in the car for two reasons. One, to provide money toward the drug purchase, and two, to be seen by the New York source for future trips. That's at the record page 21. Detective Mitchell learned from text messages sent by the GPS that the car drove through the night from Raleigh to New Jersey. Detective Mitchell then manually followed the car's movements by contacting the GPS device from his cell phone. Mr. Lane was driving the car when Detective Mitchell electronically tracked its path through Rocky Mount and then followed it into Wake County. Given the totality of these facts, Judge Young erred when he concluded, quote, based on the totality of the circumstances in this case, there was not sufficient evidence to determine the defendant had standing. And to your question, Judge Inman, that is the only question or the only issue Mr. Lane is here to debate.
Let me ask you this, if your client had been a passenger instead of the driver, and Mr. Evans had been the driver named on the order, would that make any difference?
It would make a slight difference. I think that Mr. Lane's privacy interest under the reasonable expectation of privacy theory comes from two places. One, it comes from him being the driver of the car, and as such, under Byrd versus the United States, he had a privacy interest in the car that gave him standing to contest the search. And additionally, I think under a legitimate expectation of privacy basis, everybody in that car, including the passengers, had a reasonable expectation of privacy in their location information. So I think that when the government uses a GPS device on a car, everybody in the car has standing to challenge the government's acquisition of that location information.
I think you'll agree that most modern vehicles come from the factory with GPS devices.
They do.
And that the factory offers services that if your car's locked or stolen or you forgot where it was, they can tell you exactly where it is, correct?
That is correct.
Okay, so why is this any different from that if this had been a factory-installed device and the the police had gotten the owner of the vehicle to agree to let them track it through the factory device.
Well, I think if the police got consent of the owner to track it, that would be an entirely different situation.
Isn't the order a substitute for consent?
It's not a substitute for consent. If it's a valid order, then Mr. Lane's challenge to it fails, and
And that was my first question. Isn't the cart before the horse? Don't we have to look at the validity of the order that's not challenged before we see if your client had rights to challenge that order?
I don't believe so. The court here, I mean, the court could have looked at the order, the trial court could have looked at the order and then looked at standing. The U.S. Supreme Court has said that analyzing standing is part of the substance of the Fourth Amendment claim, and there's no particular order you have to do it in. But in this case, the court looked at standing first and never got to the issue of the validity of the order. And Mr. Lane absolutely challenges the validity of the order.
Let me
This
ask you,
was-
let's say this had been a search warrant of the owner's home, and your client was a guest in that home and was charged when drugs were discovered in the home. Is there any difference there in this?
Well, I think if my client were an overnight guest in the home, he would have had standing to challenge the search of the home, just as Mr. Lane's connection to the car as its driver, as the captain of the ship for this trip, gave him standing to challenge the government's invasive GPS search of the car's location and movement.
Is it a lesser standard with an automobile than it is a search warrant of a residence?
Certainly, the protections of the Fourth Amendment that are afforded a home are greater than those that are afforded a car, but the standing looks at what is the person's connection to the place that was searched or the things that were obtained from the search. You know, in Katz, the United States Supreme Court said a public telephone booth affords protection to a person going in there to believe that their phone conversation won't be recorded. So, you know, the diminution in privacy that we have, or the lesser privacy interests we have in our cars versus our homes, doesn't really speak to the issue before this court, which is standing. And that comes from analyzing Mr. Lane's connection to the car, which was undisputably intensive during the time the government was tracking this car.
In terms of other cases where tracking devices even sell site location data, have not we upheld the tracking of a vehicle from Charlotte to Raleigh that was carrying heroin under a,
Is Your
not
Honor-
even a search warrant, but under a telecommunications order?
Is Your Honor referring to State versus Perry?
I think that's the name of the case. It was a case where there was a telecommunications order issued on an expected shipment of drugs from Charlotte to Raleigh, and they tracked it all the way down the interstate until it arrived at an intersection. Then they were able to locate the intersection by process of elimination.
Well, I can say to the court, you know, I know that this court in State versus Perry approved of the government obtaining cell site location information under the third-party doctrine, and without a warrant, with a lesser type of order, and the U.S. Supreme Court explicitly rejected that. That case is no longer good law after Carpenter.
I think Carpenter was a surveillance in Maryland over a period of months, and I do not think the Supreme Court in Carpenter would outlaw a same-day or a limited search based on abductee or drugs. I think what the problem was in Carpenter, the search there occurred over months.
Well, actually, in Carpenter, there were two orders that were issued. One was for 127 days worth of material, and one was for 7 days. Of the 7-day order, the government only obtained 2 days. The language in Carpenter, you know, was looking at whether you have a reasonable expectation of privacy in location records that are kept by a third party, and they looked at the extensive type of records cell phone service providers keep. But in terms of their concern, they concern about the government obtaining that kind of information, they dropped a footnote and said, we're not deciding what amount of time is required. You know, certainly 7 days is enough. Well, that's referring to the one 7-day order, of which they only got 2 days' worth of location information.
Isn't this the same thing? Isn't this tracking device nothing more than a transmitter, like a cell phone, and the detective was tracking it based upon wireless signals? I mean, isn't it the same thing?
It's different and it's worse in a number of ways. First of all,
There's a greater showing before the court to get this order than the telecommunications order, there is or not?
well, to answer the court's first question, there is a difference that is significant between even, you know, this is a bigger invasion of privacy because the government placed the device in the car and used it to track. This is different even than when you
With
carry your cell
a
phone.
court order, with a court order. It was not surreptitious like
May I-
other cases have been.
May I ask,
Certainly.
please answer Judge Tyson's questions first.
Okay. The answer to your question about if it's different or not, it is different because the government put the tracking device on the car, and you know, with our cell phones, we know they're transmitting information to our service providers. Nobody in that car knew that the government was receiving location information by a secretly placed GPS device. Additionally, in this case, the GPS device was a two-directional device, and so it was not only, you know, itself recording the location information, it was sending it back to Detective Mitchell and others, and Detective Mitchell was able to manipulate it from his home to give him more detailed information about where this car was going. That's a much more intrusive scenario than the passive transmittal of location information that happens with our cell phones without our permission, explicit permission. I'm sorry, Judge Inman.
Oh, no, I'm sorry to have interrupted. Regardless of whether Perry survives Carpenter, did State v. Perry involve the issue of standing?
It did not. It did not. State v. Perry directly addressed the issue of whether the third-party doctrine allowed the government to get cell site location information from a third-party provider without a warrant. And additionally, with regard to Perry, this court has said that Carpenter did overrule it in State versus Gore.
Correct. And regardless of that argument on the merits, again, it's your argument that we don't get there yet, because the trial court has yet to engage in any of that analysis to make any of the findings of fact that normally we see in a court order denying or allowing a motion to suppress, and we are not, as an appellate court, authorized to make findings of fact.
That is exactly correct. Under State versus McKinney, the North Carolina Supreme Court has specifically said this court can't do it in the first instance.
Thank you.
I just do want to touch briefly, we've talked a lot about reasonable expectation of privacy and that basis for Mr. Lane as the car's driver. Under our state law, he was the only person at the scene who had sufficient connection to the car to consent to a search had the police asked for that. Certainly if he has standing to consent, he should have standing to object to the search. I do want to touch briefly on there were two theories raised in the briefing on the trespass basis for standing, and I just want to talk briefly about the continuing trespass theory, and I'll leave the electronic trespass theory to the briefing unless the court has specific questions about that. As to
If your client was a defendant who had abducted a child in a car, whether they owned it or not, and the police were able to track the location by the factory-installed GPS, would your position be the same, that you would have a right to challenge the standing if that tracking had been by warrant?
So the hypothetical is that my client stole a car and abducted a child, or in his own car abducted a child?
Well, let's say it's not his car. Let's say it belongs to a third party, just like here.
And he had permission, he was a lawful driver of the car?
I don't know that's material. Let's say that he did.
No, I do believe it is material. I think that's what Byrd versus the United States sent it back to determine, because it is material. But I think if he has lawful possession of a car and the police have reason to believe that he has abducted a child, they have reasonable suspicion to stop the car, whether he has a standing to challenge how they determined that he was where that car was because there was an order authorizing tracking of it. I think he would have standing, if he's a lawful driver of the car, to challenge the order. I think that exigent circumstances in a case like that may validate the stop. You know, there's so many variables that go into these Fourth Amendment analyses that it's really hard to take that example, which is nothing like the case here, and try to give you an answer about the constitutionality of that.
If the owner of the car had consented to the placement of the vehicle and your client was in the car, all the other facts being the same, could your client then challenge the owner's ability to give the police consent for the search?
Certainly, Mr. Lane would be able to look at the circumstances of the consent, and if it was invalid, if there was invalid consent, he would have a basis to challenge the search. You know, that's always the case in Fourth Amendment cases where consent is the basis for a search. If the person has standing to challenge a search of a particular area, a home, a car, and the search is based on consent, the person with that standing can, you know, engage in the conversation about whether the consent is valid. I see that
Ms. Goldman, you've had a lot of questions, so I'll give you a couple extra minutes. I think you wanted to talk about the trespass basis for standing.
Thank you. I just wanted to talk about the continuing trespass, and I'll be very brief about it. You know, Jones tells us that the placement of the GPS on the car is a trespass. 5 justices also in their concurrences would have found under a reasonable expectation of privacy that there was a violation of the Fourth Amendment. But in this case, just looking at that trespass, Mr. Lane, as a bailee, or at the very least a limited bailee of the car, had standing to object to the continuing trespass of the GPS device. And not only its placement on the car, but while he's driving the car, Detective Mitchell is engaging with the device. Certainly if an agent had hidden in the trunk of the car while Mr. Lane was driving it and chronicled and reported its location, Mr. Lane would have had standing to object to that search. It's no different just because Detective Mitchell was accomplishing the same thing from his home using electronic means because of the enhanced technology we have now. In conclusion, I will say that the government used powerful technology to remotely track and monitor a car in which Mr. Lane had a reasonable expectation of privacy. Also, the government obtained detailed location information by means of a continuing trespass, begun when the government attached the GPS device to the car and continuing into when Mr. Lane had a possessory interest in it. For either or both of these reasons, the trial court erred in summarily denying the motion to suppress based on lack of standing. Mr. Lane wants nothing more from this appeal than a full hearing on his motion to suppress. Respectfully, Mr. Lane asks this court to send the matter back to the trial court for the hearing he was denied. Thank you.
Thank you.
Good morning, Your Honors. If it may please the court, my name is Jonathan Evans, Assistant Attorney General, and I represent the appellee, North Carolina, in this matter. The defendant's appeal challenges the rulings on the defendant's motions to suppress by the trial court judges who properly found that defendant lacked a sufficient interest in the vehicle to grant standing. The burden is on the defendant to show ownership or possessory interest, giving standing to claim infringement of rights. The hearings on these motions regarding standing took place before Judge Young and Judge Shirley, with both judges entering orders to deny the defendant's motions to suppress, along with findings and conclusions on the grounds that he did not have standing. Defendant also filed motions to reconsider the ruling on standing concerning additional case law and theories presented, which were denied by Judge Smith and Judge Shirley. In reviewing the denial of a motion to suppress, this court must examine the evidence in the light most favorable to the state, with the ultimate question being whether the ruling of the trial court was correct and supported by evidence, as the main inquiry is with regards to evidence admissibility. The initial hearing took place before Judge Young, who reviewed the defendant's standing claims in terms of both an expectation of privacy and property interests, finding that he did not have a standing in either. In its most basic sentiment, a defendant has standing to contest a search if he or she has a reasonable expectation of privacy in the property to be searched. The concept of safeguards against unreasonable searches and seizures applies specifically to that person and what can fairly be attributed to such individual as their enumerated property for the sake of guarding such rights against others. The framework for this concept began with the case of Katz v. United States, where the Supreme Court found that a person could rely on the protection of Fourth Amendment where their intent is to maintain a private conversation. Whereas the analysis for privacy, which was initially grounded only in property rights, the Supreme Court extended a constitutionally protected reasonable expectation of privacy approach in areas that an individual may still seek some reasonable ability to maintain reserved matters. The Supreme Court summed up in Byrd v. United States that one who owns or possesses a car, like one who owns or possesses a house, almost always has a reasonable expectation of privacy in it. More difficult to define and delineate are the...
Mr.
I'm sorry.
So did he possess the car?
I do not believe so, Your Honor. What is stated in Byrd and other cases requires and something in addition to mere possession and control. What the defendant has tried to argue is that his driving of the vehicle that he was given the ability to use by Mr. Evans, I believe no relation, was enough to prove possession and control. However, there is still the determination to be made as far as if he was a passenger who was simply driving, which the court did find, or the trial court did find, or if he was somebody who had possession and control of the vehicle. What the defendant has tried to argue is that he had exclusive possession and control based on the virtue of driving, yet cannot demonstrate anything more than just the limited use of the vehicle at the discretion of the person who gave him that ability. That excludes things that, like which he had argued, such as the right to exclude, being a bailee, consent, and those type of things that he has argued in his brief.
Was there any evidence that the owner of the vehicle had given him permission to drive?
I do not believe so. I believe the only evidence of Ms. Sherry Harris, who was the conceded owner of the vehicle, was that she was the boyfriend of Mr. Evans. The evidence in the record and certainly in the testimony was that Mr. Evans was the subject of this investigation. He had been the one who had been using it exclusively, the Acura that was at issue.
Was he named in the order as well?
Mr. Ronald Evans?
Yes.
I believe so, Your Honor.
As
I know
well
the Acura
as
specifically.
well as the owner of the vehicle?
I believe Ms. Harris was, but I cannot be certain. I know the Acura specifically was because he was the primary user, if not the exclusive user, during the time that the investigation was taking place, and therefore was the subject.
If I can ask
Yes,
you a question. Mr. Lane, I believe cites in his brief, an Arkansas Supreme Court case. Obviously, it is not binding on this court, but argues that it's persuasive. That's State v. Villainese. In that case, the defendants took turns driving the car. They took turns driving the car and held that they were in joint possession of the car and that each of them had a reasonable expectation of privacy in the car. In this case, my understanding from the evidence, and please let us know if you disagree, Ms. Goldman just represented to us that Mr. Lane drove for most of the 20 hours coming back from New Jersey. Could you distinguish the Arkansas case or argue why that doesn't make common sense?
Well, besides what Your Honor has clearly indicated is that it is a non-binding on this
Right.
court, it found persuasive a second court case finding the possessory interest in the search vehicle because the owner allowed him to use it whenever he wished and he freely availed himself of that privilege. Now, specifically in Villainous, there was, I believe, the driver and another passenger who were using it jointly. However, especially in comparison to this case, there was some information as far as the connection that the driver had to the vehicle. I believe they both claimed some right to the property therein and their use of the vehicle. What we have in the case before this court is the driver of the vehicle, the defendant, having no connection to the vehicle other than driving it for the brief, limited, and continuous journey within 24 hours, along with the person who gave him the right to use it.
Well, was Byrd the case where the woman got the car rental and then gave the car to the defendant to drive?
That is
without her-
correct.
Without her?
Yes.
And I think the court said, we're not going to treat this guy like a car thief.
That's
You know,
correct.
Well, if that was enough for a possessory interest, how is it not enough when here the woman, who's the person with permission, is riding with him?
When
In
you
other
say the
words,
ride- the one-
she was the, forgive me for forgetting her name, the girlfriend of Mr. Evans.
I don't believe Ms. Harris was in the vehicle.
Was not in the,
No,
was
she
not
was
in the
not. There
vehicle.
was another individual whose last name, I apologize,
Pa-
escapes me.
pardon me.
She was the one who actually had the contraband on her when the search took place.
Is it your argument that the girlfriend allowed Mr. Evans to drive the car and had no idea and did not give permission for Mr. Lane to drive the car?
I don't know whether or not, we certainly can't say, there's no evidence to say that Ms. Harris had any idea what Mr. Lane's relationship to the car would be. The state's argument would be, even if Ms. Harris gave Mr. Evans the right to use it, which it sounds like was fairly exclusive, Mr. Lane then Mr. Evans then giving the defendant the opportunity to use the car for the limited purpose that they did, i.e. taking turns driving and each having their own role in this mission to go to New York and back within 24 hours. That is limited and shows a limited connection that these other cases, such as Carpenter, such as Jones, and some of these other matters simply don't show.
So the fact that it's attenuated from Ms. Harris to Mr. Lane, you have Mr. Evans in between, you would argue is distinguishes this from those other cases.
It does. I think it further shows that distinction. However, I think just the relationship between Mr. Lane and Mr. Evans alone shows some distinction, whereas the connection is still just limited based on some of these other cases that we have. We have the case of Mr. Byrd, as Your Honor has pointed out, where there was a renting of the vehicle by another individual who then allowed him to use it. I believe the case was remanded because there was a determination, they needed to make a determination of whether or not this was a potential straw man rental, and they wanted to make sure that there wasn't some sort of issue regarding whether or not somebody wasn't supposed to be driving the car or only rented it because of him. But what the court specifically found was that the violation of the rental agreement's terms, which are normally risk allotment and things along those lines, did not invalidate what otherwise would have been a reasonable expectation of property by the sole owner and operator. What the court did indicate, however, additionally, was that being the did not hold that every driver of the vehicle has a reasonable expectation of privacy, either in some or any area of the vehicle based on mere possession or control. So trying to distinguish this case to Byrd certainly is different, number one, in the fact that there was only one driver, the sole owner and operator of it, but also that mere possession and control by the language of the court was not sufficient. The court did indicate that an owner would normally have the ability to exclude, however, without qualification, to say that mere possession and control of the vehicle, which was argued by the defendant, would have included in its ambit thieves or others who, not least because of their lack of property-based justification, would not have a reasonable expectation of privacy. So just because somebody merely possessed or controlled the vehicle, which we don't even argue Mr. Lane, the defendant, did in this case, there still has to be some other showing to connect the person who was the driver of the vehicle to that vehicle.
And who has that burden?
I'm sorry, Your Honor?
And who has that burden?
The defendant has the burden of proving standing in each case, that connection, Your Honor.
Judge Young's order appears on pages 43 and 44 of the record. He made 15 findings of fact in denying the defendant's motion for lack of standing. Are any of those findings of facts contested on appeal?
Your Honor, I apologize. I do not have his record before me. I know that specifically some of Judge Young's findings were that he considered the cases of Knotts v. Caro, which the defendant has argued have been overruled by Carpenter. I know he is, as far as the other findings, I apologize, I don't have the record in front of me to specifically address those, but I know he also indicated that the defendant was not a bailee or did not have a bailee interest in the vehicle. Therefore, based on the fact that he did not possess or control it, I know he made a distinction regarding the fact that, such as in Raucus, there is a distinction that can be made between a passenger and a person who is in control of the vehicle or the locked compartments therein.
What would the defendant have to show, according to the state, to have standing here? If the driver had been Mr. Evans, would he have had standing based upon being named in the order?
I think that would certainly go to the credence of why he would be the one who had standing, especially versus the owner of the vehicle. If we had Mr. Evans being the driver, we would have not only additional information other than the apparent control of the vehicle, which has been argued by the defendant with regard to the consent to be given. But we would also have that exclusive use, that connection, that discretion and control that you would look for in these cases. We have these matters that have people storing, such as in Byrd, not only were they the sole operator and occupant of the vehicle, but they also claimed the property in the trunk was theirs. We have further connection to that vehicle. To be maybe a bailee would give you some additional rights in the vehicle if you were the defendant. But again, I don't even think we have that, given the limited use that was granted. There was no delivery of the vehicle specifically to the defendant.
Is it material in this case whether the defendant was a passenger or the driver to the state?
Was a passenger or the driver?
Is it material to the issues before us on whether or not the defendant was the passenger or the driver at the time the vehicle was stopped?
I don't believe so, Your Honor. I would argue, or I would certainly state that apparent control in a consent case would certainly be based on the observations made at either the time of the service of a search warrant or the time of a traffic stop, the driver of the vehicle. They would certainly be the one apparently in control of the vehicle and give credence to their ability versus somebody else to
Is that the
give
captain of the ship doctrine kind of that was mentioned?
It could be, Your Honor. I think that, again, the captain of the ship I think a captain can be somebody maybe different than somebody who's driving the ship at a certain time. The captain of the ship may be the one who plots the course, who tells us where we're going and why we're doing it, maintains that vehicle, and has control over that. Somebody may be steering the ship at the discretion of the captain or at the direction of the captain, which I think we have more analogous to this case. This vehicle, we don't know too much about how exactly the three individuals who were in the vehicle came together. But we certainly have the ability to show that Mr. Evans was the one that provided the vehicle. He was the one that, based on the facts, and I hate to assume, but based on the facts, knew whoever the connection was in New York to the point where he had to travel with the vehicle and had to be present there to meet that connection. Mr. Lane, the defendant, knowing how to get there and driving there and back, again, was at the direction of Evans, and he maintained his presence in the vehicle the whole time. I'm sorry.
Mr. Evans, no. Can you respond to defendant's argument that if he had standing to consent, surely he has standing to object to the reasonableness of the search?
Your Honor, the defendant, in their brief and in their argument, have sought to equate consent that can be given by an individual to illustrate a paramount right of privacy in the vehicle. But it is worth noting on appeal that the defendant has claimed that Ronald Evans could not have given valid consent. However, during arguments, the defendant admitted in front of Judge Young in 2017 that Evans, as the property owner, his rights can be asserted over the person he earlier made the bailee of his car. Despite the bailee assertion, we would still state that that stands. As we indicated, apparently is a rebuttable presumption just based on the definition of that word. Other information either collected prior to or subsequent to that observation that you would normally have upon meeting the vehicle or the location would provide some additional information to see who apparently is in control. There is no information in this case that would indicate that law enforcement believed the defendant to be apparently in control of this vehicle while they were doing their interactions with it with the GPS tracker.
They didn't know who was driving, did they?
They didn't know who was driving. They knew who exclusively used the vehicle. And upon coming to the traffic stop or conducting the traffic stop based on the speeding charge, when it re-entered Wake County, they were met with the defendant in the driver's seat, but they were also met with Mr. Ronald Evans, who was the person who was the subject of this in the back passenger seat. We continue to have this information, unlike a regular traffic stop where you have the driver who is the immediately observable person in control of the vehicle. We don't have that in this case. We have the additional information that law enforcement would have to know we are tracking Mr. Evans, we are tracking the vehicle that Mr. Evans uses. When we stop the car, he's in the vehicle. There's nothing apparently, there's no lacking of information that would make them think the defendant apparently was in control of the vehicle.
Is the legitimacy of a traffic stop on an admitted crime being committed, is that based or is that only valid if it's random? And the rest of my question would be, is there an independent basis here to uphold the conviction based upon the lawful stop?
I think based on your first question, and admittedly, there are circumstances where there is a tainted observation of the fruit of the poisonous tree in certain circumstances where there has not been that attenuation or that intervening factor.
But that would require a showing of the unlawfulness of the underlying order, would it not?
That would, Your Honor, yes. There would have to be some reason to
don't
believe
have
that would have to be some reason for the tracking to not have been valid, whether based on the order being invalid or not proceeding pursuant to the order, or some, as Your Honor's indicated, there being some reason why the order would not have stood. Or
Can the stop stand alone, is what I'm asking.
The state would argue that it could. Again, as counsel has admittedly pointed out, that's not before this court as far as the briefing, but the state argues, based on our harmless error argument in our brief, that there was a finding of reasonable suspicion that has not been challenged. Probable cause has never been challenged in this case. There was an argument made of tainted observation that was indicated in the last motion that went before Judge Shirley before trial, pre-trial. One of the theories there was the tainted observation that the defendant has claimed, and that they claim in their brief that they have argued throughout this. However, based on Appellate Rule 10, subsection A1, there has to be a ruling made of a motion brought before the court to suppress evidence. There was no ruling made. It was never brought by the defense before the court, and there was nothing. That is where the state's argument of an abandonment of that theory comes. They stated it in their order or in their motion. However, they never made that argument from the court. The court never brought it up themselves, but the defendant never obtained a ruling on that. Based on the fact that there has therefore been no ruling that could be found or has been preserved, and we also have the evidence of the reasonable suspicion and probable cause being sufficient, any finding that this court would make regarding this standing, potentially going to the court order and then challenging the court order potentially, would still not would not exclude the evidence that they are challenging. That is where the state's argument as far as harmless error, and as the court has pointed out in the prior arguments, showing prejudice in this case, again, that goes to the connection that the defendant would have with this vehicle, the relationship that he had with it, especially in relation to Mr. Evans' relation with it, and him providing the vehicle, him being the person who's in exclusive control, and knowing what they were doing in this case as far as the use of the vehicle and the scope of its use. It's hard to show prejudice in the fact that he has been given multiple chances to go in front of multiple courts with new case law, and each one of those has found, again, no standing based on multiple theories. I'm not sure if there was any other questions regarding consent. Just briefly touching on the case of Carpenter v. U.S., it did involve a challenge to the court orders that law enforcement used to gather the several suspects' cell site location information sought in relation to the investigation. As part of the analysis regarding the privacy interests involved, the Supreme Court was conscious of maintaining the same ideals of protections that originally encompassed the Fourth Amendment. The opinion centered around applying the Fourth Amendment to innovations in surveillance tools, and as has been pointed out, did have some analysis regarding the third-party doctrine and whether the information was volunteered or a lack thereof volunteering to a third party, and that's what ultimately did result in the case's decision. However, the Supreme Court did not reject all advancements in technology, but provided a framework for their analysis given these guidelines. The Supreme Court was clear in outlining the subject addressed in Carpenter was cell site location information, writing specifically when the government accessed CSLI from the wireless carriers and invaded Carpenter's reasonable expectation of privacy in the whole of his physical movements. Despite recognition and use of this language from Jones' concurrence, Carpenter did not summarily foreclose all surveillance of an individual's movements as violating their expectation of privacy. The main takeaway from review of Carpenter is its own writing. This case is not about using a phone or a person's movement at a particular time. It is about a detailed chronicle of a person's physical presence compiled every day, every moment, over several years. Such a chronicle implicates privacy concerns far beyond those considered, as they stated in other cases. They gave the...
So are you saying that the application for the mobile tracking device authorization, this is on page 15, 16 of the record, and the order appears on 18 and 19, signed by Judge Collins. Is it the state's position that this showing is much more specific than the communications order in Perry? And this is based on probable cause, correct?
Yes, Your Honor. And
Whereas
that-
the order in Perry is not necessarily, it could be based on suspicion.
Correct, Your Honor. And that was the distinction that Carpenter ultimately did make, was that the CSA, which allowed for reasonable suspicion to be the standard, was not sufficient and needed to be probable cause. And that's what led to a lot of the cases being distinguishable, because they were that previous determination. However, they were able to, based on good faith doctrine, use CSA in this and in many other cases based on the fact that that was the stated standard.
Has there been any challenge to the affidavit or Judge Collins' order that it was not based on probable cause?
I believe, I'd have to look specifically at defendant's motion to suppress the order specifically, which I believe would have been at the very beginning of all this. That is to say, when they initially challenged it before the state argued that there was no standing. But I believe that they argued that it would have not have met the standard of probable cause. And they probably indicated that it wasn't reasonable suspicion as well. But again, without having that in front of me, I apologize. I can't state specifically what that was. What Carpenter stood for ultimately was that there needed to be a determination of the method and duration of monitoring as part of the analysis. Again, the defendant has the burden of proving that standard. But as the court indicated, there were even greater privacy concerns than in GPS monitoring of the vehicle, which was considered in Jones, in Carpenter. That was 127 days or something around that, where they were able to obtain not live tracking, but going back and recreating somebody's movements, as opposed to
They were
live
able
tracking.
to establish a pattern as opposed to a one-time trip.
That, or even, that's correct in this case, but even in cases that are shorter term, even shorter than what was articulated in Jones, them determining that an individual has more pervasive tracking, the five justices agree that longer-term GPS monitoring of a vehicle would constitute a search. There is that distinction. While the defendant would have that line drawn closer to the rudimentary tracking and shorter term part, there was clearly a determination in Carpenter, adopting the language of Jones and the concurrence in their determinations, that there is something to be considered in this analysis of the case. Given what happened in each one, this again goes to show that not all tracking of an individual's movements is automatically a violation of the Fourth Amendment's rights, but instead requires analysis of the circumstances of the case. And the state would even argue that this is on top of the fact that there still needs to be a showing by the defendant of what their connection to the vehicle was.
And the mere presence or the fact that they were driving, standing alone is not enough.
That's correct, Your Honor. And in the cases of Byrd and those matters have indicated that the mere presence is not sufficient. Possession and control is required. The state points back to the case in Rockus finding that Kathy
Did
Jones...
Evans have the authority to give someone else permission to drive?
I'm sorry, Your Honor, I couldn't hear
Did
you.
Evans have the authority to give another person permission to drive the vehicle?
I believe so, Your Honor, in some limited capacity. He clearly exhibited some exclusive control and use of the vehicle, which, as has been indicated in the Bailey argument, the defendant has actually cited to some cases that says, depending on how much control the defendant exercised over plaintiff's property, I think that would go to something like this, stating authority that Evans would have to give somebody else the ability. Again, that would be limited in the ability that he has to use the vehicle, but I think he may have had the ability to utilize it. However, again, there needs to be a consideration that there was not a delivery as required for a Bailey by Evans to defendants specifically. Based on the defendant's arguments and their citation to the definition, there needs to be a determination of delivery, which would be a relinquishing exclusive possession, custody, and control to the Bailey. The defendant has supported this by stating that both Evans and defendant were Baileys of the vehicle since it was owned by another. However, they do not explain how Evans delivered the property to him when the agreement was for all the individuals in the vehicle to drive and travel together on their brief journey to New York and back. The defendant is essentially trying to have it both ways in their argument of a bailee and their property rights, that Evans relinquished exclusive possession and control, but that his remaining with the vehicle and being a part of the group's mission did not matter. The case law cited by defendant, again, states that control that is exhibited by a defendant on the plaintiff's property would be something that would lead to a determination of a bailee and property interests. What we have in this case is very limited evidence of any control by the defendant. He was given the opportunity to use the vehicle while Evans was in the vehicle, while he slept, while they all took some variation of terms, even if defendant drove it the main amount of the time. But as far as defendant's argument as far as a right to exclude, Byrd stated that one of the main rights attached to property and one who owns or lawfully possesses or controls property will in all likelihood have a legitimate expectation of privacy by virtue of the right to exclude. The defendant has argued the language positing that as the driver of the vehicle, he could exclude others from entering said vehicle by locking the doors and driving away, or driving away, illustrating a possession and control of the vehicle. Again, defendant was in sole possession or control of the vehicle, the rental car in that case, while the rationale of the court was articulated in the point that a driver can exclude third parties, including the carjackers, which they, of course, would want to. It does not stand to reason that a driver who derives his ability to operate the vehicle from one who remains within during the journey could exclude such individual and would therefore have some greater expectation than all others, as defendant would have this court rule, essentially.
Now, Judge Young made findings on the lack of any bailment in his order, did he not?
He did, Your Honor.
And is that finding challenged, to your knowledge?
Whether it was explicitly or just implicitly challenged, the defendant has certainly argued that they were a bailee in this case. Again, not knowing the exact language of their motions or their challenges on appeal, they have certainly argued that they are a bailee either by Evans or as a limited bailment. Again, there's been no information indicated what a limited bailment has with respect to some right and property. There is still a distinction that needs to be made regarding rights and property, that a right and property to the entire vehicle, such as what we saw in the 2012 decision of Jones, where he was the exclusive driver of his wife's car, and there was a concession that he, being the exclusive driver, had rights analogous to a bailee.
That raises an interesting question. If you take your car to a valet and you turn over the keys to the valet and they take your car, I think that's a classic definition of a bailment. Do you agree with that?
I would agree, Your Honor. There's been an exclusive delivery, or a delivery of the exclusive possession and control of the vehicle to another person for a specific reason.
But if the person in possession stays with the vehicle, let's say that the person who owned the vehicle or who had permission to drive the vehicle stays in the car at all times, has there been any bailment created if that person is still in the car?
Without further facts, Your Honor, I don't believe so. There needs to be some showing of what exactly the mission may have been or what the purpose was. The state would point to defendant additionally citing to State v. Jean or Jean, which was an Arizona case from 2018, again, not controlling. However, the point of the defendant citing it was the logical extension of Carpenter's embrace of Jones' concurrences, where they articulated passengers traveling with the owner in a private vehicle generally have a reasonable expectation of privacy that is invaded by the government's continually tracking the vehicle. While not binding, again, Carpenter and Jones don't discuss anything regarding passengers. However, the court found that a vehicle's owner who pays another to drive in the owner's company still maintains the right to immediate physical control of it against all others. As such, the driver would not have a possessory interest in the vehicle, but instead the owner maintains it, even if the owner leaves the car and the driver remains with it to wait for the owner. The driver also did not have the right to exclude. Again, this is not a binding on this court, but I think it illustrates, even though the defendant cited it, this is contrary to the defendant's arguments, and it further states that there really needs to be some showing as far as what constituted the distinction in the delivery and how that led to the bailment.
I think Ms. Goldman said the state had stipulated that he had permission of the owner to drive the car. Were there any other stipulations, or I was just looking at the affidavit of standing, and it doesn't really say anything other than the identification of the car and that he was driving it. It doesn't say who owned it.
In the court order, I don't believe so,
Yeah,
Your
it just
Honor.
says that Mr. Evans had given him permission to drive the car, but it didn't say what Mr. Evans' connection to the vehicle was. I mean,
You're-
hypothetically, it could be a stolen vehicle that Mr. Evans said, here, I stole this vehicle, you can drive it. I mean, you know, and I know that's not the case, but I'm just trying to figure out the connection and where that evidence is.
Yes, Your Honor, and just to answer your question, then I'll wrap up. I think there's certainly been an understanding, if not a concession, during the trial court that Mr. Evans had the vehicle from Sherry Harris, who was his girlfriend. I believe at one point in the transcript it says it was his wife, but I believe it was his girlfriend, and that Mr. Evans, Mr. Lane, and the other individual traveled for the purposes of going to New York and back, them all a part of that. I don't know what was contained in the court order regarding, obviously Mr. Lane had there's no statements regarding Mr. Lane in the court order, as he was not contemplated, and the use was exclusively Mr. Evans. But the state has never conceded, or the state has never argued that Mr. Lane was invalidly driving the vehicle, that he had stolen it or anything like that. He was certainly in some sort of group mission or determination by all three of the passengers. There's less information what the female passenger's part in the mission was, but certainly that would be a concession, that he was driving the vehicle, that the state conceded that he possessed the vehicle. I don't know that that necessarily is accurate based on the information, but certainly he was the driver of the vehicle, at least during some portion of it. The defendant has indicated in his affidavit how long he believed that to be. However, all we have as far as the evidence is when the vehicle was stopped based on the reasonable suspicion of the speeding charge and that information, the driver was the defendant. For these reasons, the state, and those stated within the brief, the state requests that this court affirm the rulings of the trial court. Thank you.
Thank you. All right. And so for rebuttal, like I said, I had given you an extra 2 minutes before, so wherever we were, +2. And is your timer down there working? Is it showing the time?
It says 2 minutes, 23 seconds.
Okay, that's okay. There was a previous court session where it was not showing up to the council, and I didn't realize that, so I just want to make sure you had it.
All right. Thank you, Your Honor. Just quickly to go through a few of the points that were raised, I did want to make one factual correction. It was Mr. Lane who was in control of this trip, not Mr. Evans. That information was before Judge Young in the supplemental report that was attached to the affidavit on the motion to suppress at page 21 of the record, where Detective Mitchell discusses his interview with Aretha Lyles, who was the woman in the car, and she explains that it was Mr. Lane's trip, that he had done this before, and that Mr. Evans had never gone on the trip, that she had never met Mr. Evans before, and that the two passengers and Mr. Lane went to Mr. Evans' house, picked him up, got in his car, and the four of them then headed out. So, you know, on the captain of the ship analogy, it was clearly Mr. Lane who was the captain of the ship on this trip, according to the evidence that was before Judge Young. Just briefly addressing the state's claim that Evans' presence in the car defeats Mr. Lane's standing, that specific argument was rejected by our Supreme Court in State v. Reed. Our Supreme Court said that the trial court erred in holding that the defendant there did not have standing based on facts that are indistinguishable from the facts here. Those facts were that Mr. Reed was driving a car, a rented car, and the woman who had rented the car was his passenger. And Justice Morgan said, under those facts, the finding that Mr. Reed lacked standing to contest the search was unsupported. So if that finding was unsupported, then certainly Judge Young's finding of a lack of standing is unsupported in this case. Additionally, in Byrd, the Supreme Court, which said generally that one who drives a car has standing to contest the search because of their control, discussed the privacy interests that Mr. Byrd would have had the actual renter, the authorized driver, been his passenger, and the court had said in its analysis that the privacy interests would be the same. Just quickly, with regard to the stipulation at page 39 in the record, the state, in its response to the standing issues raised by the defense, said that the state in the present case does not dispute that Mr. Lane was permitted to drive Sherry Harris's Acura at the time of the stop and was in possession of Ms. Harris's vehicle at the time of the stop. That's at page 39. As to the preservation argument that council has raised, in the January hearing, January 16th, 2019, before Judge Rosier, at page 11, the state said, as to the tainted observation theory, Judges Young and Smith already ruled lack of standing. Mr. Lane was never able to fully make his tainted observation argument because he was never given standing to challenge that initial search. There was a lot of discussion in the state's argument about the target of the investigation, but as Rakes told us, the target of an investigation is not a necessary or sufficient condition for standing. It's just not part of the analysis. As to the arguments about whether or not Mr. Lane was a bailee, I cited in my brief the case of Atlantic versus Adcock, which looks at whether or not the bailor can obtain the property back without the cooperation of the alleged bailee. Certainly in this case, when Mr. Lane was driving the car, he could not. For all of those reasons, Mr. Lane asks this court to reverse the trial court's denial of the motion to suppress based on a lack of standing and remand for a hearing in the first instance on the defendant's challenge to the sufficiency of the order allowing for the GPS search.
On your last point, one quick question. Are you saying that Mr. Evans would not have had the authority to reclaim possession or driving the car from Mr. Lane?
I'm not saying that he wouldn't have had authority. I'm saying that he couldn't have done it without Mr. Lane's cooperation, and that is one of the main defining points of a bailment relationship as discussed in Atlantic versus Adcock.
Well, again, isn't the point is if you have a right to possession as the bailor, that you do not need the bailee's cooperation to regain possession? You have a legal right to that possession regardless if you have cooperation of the bailee or not.
Yes, I think the court is right about the legal right to it, but I think that the existence of a bailment is defined by what it takes to get the extent of the control that the bailee exercises and what it takes for the bailor to reassert control over the property.
Right, but permission by the bailee to return is not an element of the bailment, correct? Because the bailor has the legal right of possession.
Has the legal right, yes, Your Honor.
Thank you.
Thank you.
All right. Thank y'all very much for your arguments. And we're going to take just about a 5-minute recess to switch out for the other case so our amazing IT people can get everything straight for the live streaming of the next case.